Good afternoon, everyone. Today, I am going to address a concerning practice that undermines the very integrity of our legal system, that is, forum shopping and registry manipulation in the higher courts. This issue not only affects litigants but also erodes public trust in the judiciary. Let's take a closer look at what these practices are, why they are happening, and how we can effectively address them. So first, understand forum shopping and registry manipulation in higher courts. Forum shopping is when litigants, often with the assistance of their legal counsels, mostly the senior counsels, attempt to get their case heard by a specific judge or bench, believing that they will receive a more favorable outcome. Registry manipulation refers to influencing the court registry to list a matter out of turn or on specific boards to strategically time the hearings or shift cases to preferred benches. These practices often occur in higher courts where high-stake matters such as corporate disputes, high-profile political cases, or sensitive legal challenges are being litigated. Unfortunately, this manipulation is not limited to just lawyers, but sometimes involves collusion with the court registry and the secretarial staff. Why do forum shopping and registry manipulation occur? Let's look at that in detail. Forum shopping occurs because not all the judges are the same. Some are perceived to be more favorable towards certain legal arguments, and litigants often try to get their cases heard before those judges. Senior counsels, with their deep understanding of the judiciary, exploit this perception by timing their mentions or delaying notices so they can have the case heard by a judge more likely to rule in their favor. Registry manipulation is another tactic where, by influencing officials with the registry, cases are either expedited or delayed, depending on the strategic advantage. In some cases, matters are placed on the main board or supplementary board or conveniently shifted to the final hearing board without following the standard procedures, allowing the party in question to try their luck with a more favorable bench according to the wishes of the senior counsels representing the respective parties. Some of the examples of forum shopping are the Sahara versus SEBI case, and also the National Herald case, and the Vodafone dispute, and then we have Jayalalitha disproportionate asset case, and we have Dilip Pense versus SEBI case, and then we have the Amrapali group case. In all these cases, what used to happen is the counsels and the legal firms and the galaxy of legal pundits used to move their cases between multiple benches of the higher courts, and also sometimes used to litigate in multiple higher courts, hoping to avoid scrutiny by different judges. They filed appeals, interim applications, and stay petitions in different jurisdictions, delaying justice for the justice seekers. Irrespective of Indian courts adopting several approaches to prevent the forum shopping in higher courts, yet the practice of forum shopping is freely happening in the higher courts. So, when this kind of forum shopping happens, what kind of dealing that one needs to do when they observe the forum shopping and registry manipulation? How can we deal with that? Because they are unethical practices, and to deal with them, we need to explore the key legal strategies as a part of defense. That is, raise the issue before the court whenever you find a forum shopping or a registry manipulation. Then you need to boldly raise this issue before the court and we need to work on ensuring the transparency with registry. And then when we speak of this forum shopping in front of a judge, we need to cite the case laws and precedents, because several Supreme Court rulings condemned forum shopping. We can cite these cases like Union of India versus N.S. Ratnam and Sons 2015. The court has disapproved of litigants manipulating the system. Using these precedents strengthens our argument against manipulation, demonstrating that judiciary stands firm against these tactics. And also we need to hold the counsels, whether they are senior counsels or whoever it may be, we need to hold them accountable. The role of a senior counsel is pivotal in these manipulative practices, while their expertise is essential in complex matters in assisting the court in resolving the legal point of issue in various cases. But most of them, for their prestige and for their standing, they tend to resort to these practices. That's where the Bar Council plays a crucial role in upholding ethical standards. If a senior counsel is repeatedly engaging in unethical practices like forum shopping or delayed notices, a formal complaint with the Bar Council can initiate an inquiry into their conduct. Then we need to have judicial reforms and oversight. This may be a far-fetched generalization, but an oversight at every level is of utmost importance. Many courts today are adopting digital case management systems, and we need to progress towards AI-driven case allocation system to reduce human intervention in assigning cases to specific benches. This technology can ensure that cases are assigned randomly, minimizing the scope for registry manipulation. In addition, judicial oversight is key. Judges themselves must be aware of these tactics and take a proactive stance against them. Courts can issue directives to registries to streamline case listing procedures and ensure that matters are listed in a fair and transparent manner. Advocating for greater oversight of the registry can go a long way in reducing the registry manipulations. This includes pushing for digital tracking systems that allow litigants to track how and when their case is listed, reducing opportunities for influence, introducing independent officers to oversee the registry's actions can add an extra layer of scrutiny and ensure that the case listing is done impartially. Over and above that, in cases when forum shopping becomes evident, courts can also act suo motu. Judges must be vigilant and ready to take corrective measures if they detect attempts to manipulate the process. Reprimanding litigants or imposing penalties for deliberate attempts to shift cases can serve a strong deterrent. We have seen that senior counsels often wait for a favorable bench. Courts can introduce strict rules stating that once a case is mentioned, it must proceed regardless of bench rotations. This would prevent delays and force counsels to address the matter head-on rather than waiting for favorable judge. In conclusion, forum shopping and registry manipulation are serious threats to the fairness and efficiency of the Indian judicial system. By adopting measures like increased transparency, judicial reforms, holding senior counsels and respective other judicial professionals accountable, and pushing for oversight of the registry, we can significantly reduce the unethical practices. As members of the legal community and citizens, it is our collective responsibility to ensure that the judiciary system remains a place where justice is not only served, but served impartially and without manipulation. Together, we can help restore trust in the system and ensure that justice is delivered without undue delay or favoritism. Thank you for watching. and let's keep the conversation going and work towards a more transparent and just legal system.